Doctor?
Okay.
Make sure you do talk. Welcome to Divorce Café, the podcast where we demystify, detangle and hopefully detox the legal processes that follow a separation with the experts in the legal world. She's Shelley Fennell and I'm Tiny Henderson. Today we have two special guests. We welcome back Divorce Café regular, if we're cheeky enough to call you that, Vivian Crawshaw, KC. Viv is an expert in the area of both spousal maintenance and, which was last time's topic, care of children work, relationship property in general, but she has a particular expertise in the claims available to spouses and partners against trusts. She's been a King's Counsel since 2018, and it is hard to overstate how highly regarded she is among her colleagues for her skills as a trial lawyer, as a lawyer in mediations, and as an all-round classy piece of work. We have previously described her as the Captain Marvel of the legal world. Turning to our other guest, to call her a sidekick would do her a serious injustice. She is another very smart lawyer. She clerked at the High Court at Auckland and then spent 7 years in the hurly-burly of commercial litigation and investment treaty arbitration in London. Returning to New Zealand, she chose family law, and she chose Viv as the person that she wanted to work with to learn that trade. They were partners in their recent foray into the Supreme Court in the case of Sutton and Bell. Welcome to your first foray into Divorce Café, Barrister Sam Wilson.
Thank you, it's lovely to be here.
Now, when we last spoke to Viv, she was waiting for a decision from the Supreme Court on Sutton and Bell. That was a case that centred around a house that Mr. Sutton had put into a trust about 16 months into his relationship with Ms. Bell. Some 7.5 years and 2 children later, that was the main or the only principal asset for division between the parties when they separated. Cue a 5-year battle, culminating in New Zealand's highest court. The case has raised questions about when romantic relationships trigger property implications and when the freedom to deal autonomously with your assets without considering the other person ends. Few lawyers can say they've argued a case in the Supreme Court, and only half of them can say that they won. And when they did. Viv and Sam are here so we all better understand Section 44 of the Property Relationships Act, to chew over the quirks and turns of this fascinating and anxiously followed case, and really just as an excuse for us to get to hang out with Viv again. Now, to break the ice, Sam, I think we might ask you to pick a question from the bucket.
All right. If you had the power to make one change in the world, what would it be? Ooh, yikes.
Viv, you're allowed to go first if you want.
No, let's
go
with that.
I mean, I honestly, it sounds very trite, but I think it would just be not having the kind of inequality we have in all sorts of ways between people everywhere in the world. But yeah.
I think that would pretty much cure everything.
Yeah,
actually.
that would be the ultimate change, I think.
Yeah. Awesome. Viv, have you got one?
Yeah, we're still struggling with some issues of institutional racism. We still have issues where women aren't treated equally. So I'm with Sam on that. Those sorts of issues still require improvement, not to mention economic inequality, which unfortunately seems to be increasing.
Yeah, I like those answers. I'm with you. So the first question is in the section we call the basics. What are the key sections that were being considered in Bell and Sutton? And Sutton and Bell was in the Supreme Court. And can you bring us up to speed on that?
Yes, well the case really focused on Section 44 of the Act. That's about dispositions to another entity, in this case a trust, where in order to defeat the other spouse's claim. There was also discussion about when de facto relationships start, so that's a bit of a focus on Section 2D. There was also discussion about Section 26 and 26A as well. And Section 21 came into consideration, which is the ability to contract out of the Act as well. But the real focus was on Section 44 in this case.
Yeah, and you did some really clever arguing about the pulling out the words of the section, which hopefully we'll get into later, which might have been your work, Sam. I'm sure it was both your work.
Got to give Sam credit for much of the
yeah,
work in this case.
No.
Awesome. Okay, and section 2D, that's the one that talks about, it defines the meaning of a de facto relationship. So it says a de facto relationship is a relationship between two persons aged over 18 who live together as a couple and who are not married or in a civil union. And that's that key definition of what the heck does live together as a couple mean. And that question was a bigger part of the Family Court, High Court, Court of Appeal cases, I think.
Family Court and High Court?
Yes. Yeah, so we'll get to that, but yeah, we can, thank you, Viv. Awesome. So question 2, what were the facts of the case and what happened as it moved through the courts? Can you tell us the story?
Yeah, do you want to do that? I'm happy to pitch in.
I've got a bit of a timeline here. If you want to.
Sure. So essentially what happened is Ms. Bell and Mr. Sutton met, and not long after that Ms. Bell moved into Mr. Sutton's home. I think that was early 2004. Now there was a dispute about essentially the capacity in which she moved in, and that was what formed a lot of the basis for the argument in the lower courts. But she did move in. They shared a bedroom. She operated her business from the spare bedroom in the home.
They clearly had a sexual relationship.
They did, yes.
So just to clarify, who were you acting for at the Supreme Court?
We were not. Oh, in the Supreme Court, we acted for Ms. Bell.
Okay.
Yes.
But we hadn't represented Ms. Bell until that point.
Right. Okay.
Yeah.
Sorry, carry on.
So the relationship progressed over the course of that year, and then towards the end of 2004, Mr. Sutton won a raffle where he got a free consultation with a lawyer, and he went along to that consultation and he received advice that he should transfer the home in which they were living, which was at that point owned by him, into a family trust. And that took place in November, and not long after that, I think it was only about a month, Ms. Bell fell pregnant with their first child, and then their second child was born, I think, the beginning of 2009.
Yeah, yep.
And they went on to have a fairly lengthy relationship, and at the end of that, the only item of property that would have been available for division under the Act was that home. But it had, of course, been transferred to the trust. And so the big issue was then whether Section 44 could apply to that transfer.
Because if the distinction between a family home being owned by one of the parties and a home that they live in as the family home but that's owned in a trust is what? That it doesn't fall in the definition of
that's
family
right.
Fall within the pool.
Because it's not owned by one of the parties.
One of the parties. Yep. Cool. Okay.
And another important fact, which we made mention of in the Supreme Court, was that Mr. Sutton had settled an earlier claim by his first de facto partner or wife, I can't remember whether they were married, and bought her out of that very same property just prior to Ms. Bell moving in.
Yes. And if I can add the other interesting detail about the same time was that when she moved in February 2004, March, she became aware of this law that would make the family home equally shared. Do you want to tell us about what she...
Yes, well, she did some Googling, I think, and she basically wrote to Mr. Sutton. She wrote him an email saying, look, I've been looking into this, and your dad's not very happy about me moving in to you with you to this home, and if we do that for 3 years, then the Property Relationships Act will apply. So you should go and make sure you're protecting it as your separate property. And that email did become a really important part of the case, because on the one hand it was said that that was evidence of Mr. Sutton's knowledge that transferring that property would defeat her claim, and we'll
That
come
comes
to
to-
talking
yeah.
about that. And on the other hand, there was an argument that, you know, she was telling him to do this, and how could he
So that
possibly
she
be?
consented. And we'll get to that too in the
Yes.
context of Section 21. Yeah. And there's an interesting story behind the emails, which I think we get to a little bit later on top of that.
So just in terms of practicality, so she moved in
They met in July 03.
03, moved in.
They went on a number of holidays
Yes.
together.
Yeah.
She met his family who lived overseas, or his sister, I think, who did.
Had
and
Christmas with her, I think,
Yes.
before they'd even moved in.
Then she moved into the home. The High Court later found that the de facto relationship did not start until round about January 2005.
So after Christmas with
after-
the family.
Well,
He has
even
moved in.
after he set up
After
the
he
trust,
set up the trust,
after he sold the house to the trust, but not before the
Not
transfer.
before the transfer.
After she fell pregnant, or around about, I think it was, they said December 04,
Yeah,
or
January
January.
Somewhere
05.
between.
But after they've been living together 16 months, been together 16 months in a romantic relationship, living together 8 months.
And so had she moved in at the point that he put the house into the trust?
February 04 she moved in.
She was in the home, but not as a de facto partner. At least that's what the High Court found, and that wasn't challenged on appeal to the Court of Appeal, because the High Court found that didn't matter, because the disposition was, Section 44 was still engaged in terms of the disposition, and that finding was basically upheld throughout the Court of Appeal and the Supreme Court.
It's a really interesting discussion. Yeah, why wasn't it appealed, do you think? So the family court, the first time that this case hits the courts was in the family court, and Judge Clarkson says, oh yeah, they moved in together in February 04, they'd been together for a reasonable amount of time. They were in a romantic relationship, they shared a bed, they presented as a couple, they had holidays together, she'd met his family. That's a de facto relationship from the time they move in.
And they were living together.
Yeah. What's the line about the presumption with Section 2D of cohabitation? It's a strong, rebuttable presumption that's when you're living together as a couple. So you can rebut it. I think, I can't remember the case that that's in. So
I think the Court of Appeal said that, and the Supreme Court actually expressed some doubt about whether they agreed with there being that.
they said that another
Yeah.
judge might have made a different decision. Yeah.
I'm not sure about that.
Yeah.
They're very fact specific when de facto relationships start. It wasn't appealed, that finding wasn't appealed in the High Court. Who knows? It was a judgment call, and you know, there are cost considerations.
Yes, because they got the outcome they wanted at the end of the day, and I suppose
Exactly. In substance, they nevertheless won.
could they have appealed it when he appealed it to the Court of Appeal? Could they
Yes.
have added their appeal in
Yes.
there? Right,
Yes.
but
Because
didn't
you
for
would be
whatever reason.
supporting the decision on different grounds, and you can provide a notice to that effect.
So it wasn't relevant for them, but I could see it being really relevant for flatmates or someone living together for a year,
Yeah, well,
and that's not considered to be the start of their relationship.
Well, there's those, how many there are, A to I indicators of a de facto relationship, which is what they looked at, and like Viv says, yeah, it's very fact specific, and there must have been some calls.
There's a nice case that referred to the date of separation as being, and this is a case of Benson and Ball being bedevilled with difficulty, which is lovely alliteration from Justice Priestley. But that equally sort of applies to the start date of a de facto relationship. There isn't a bright line. It's not like marriage or even an engagement. You know, marriage has a defined date where you might be committed when you're engaged, for example. So, but a start date of a de facto relationship is pretty amorphous sometimes, and there are some factors going one way and some factors going the other way. You know, potentially that was a factual finding that was appealable. It wasn't, but it ultimately didn't matter in this
Still
case.
an interesting case, If anyone's interested, you can look into D2, which talks about the things that a court will consider, but the court gets to ultimately put whatever weight they want on the different factors. So some of the things are how long the relationship's been going, are they living together, is there a sexual relationship, are they financially interdependent, have they bought property or assets together, do they have or what's the degree of mutual commitment to a shared life. So these are, it's like Ted Lasso recently said, quoting in respect of the offside rule, quoting Hugh Hefner talking about pornography, it's hard to describe, but I know it when I see it. Maybe, but
good old Ted.
Yeah, so there's a few more things in that. Is now a good time to tell us about those emails, because there's a little bit more in. Well, one of the emails that she sends, the one where she says, oh, there's this law coming up and you better get some advice and you better put your property in a trust. She also says, maybe we can get around it, I'll just move in for 6 to 9 months and then I'll move out again, and I won't make any contribution, I won't pay for any renovations, and the cleaning doesn't count. So that is relevant to
so it's an indication of impermanence, and that mightn't have been helpful.
Yeah. Okay. Cool. So they go on holiday together in Rotorua. He goes and sees the lawyer after he wins the raffle in September. Then start of November he sets up a trust. End of November he sells the property to the trust. December they get pregnant. December and January they go away on another holiday. Their de facto relationship, so says the High Court, begins, and then the relationship continues on.
So
then
there's also another important fact, which was that the file from that lawyer who set up the trust and was involved in the conveyancing of the property to the trust had a file note which was discovered as part of the proceedings, which had on it the words risk/relationship property, which was quite good evidence that at the time this transfer happened, that Mr. Bell was aware that there was a risk and there was relationship property. There was a risk that that family home that they were living in, which wasn't then defined as a family home because they weren't in a de facto relationship, would become relationship property.
Yeah, so that on top of her email telling her things. Yeah,
and his previous
relationship.
Recent experience.
Yes.
But I think we see a lot of people who their children or they may be entering into relationships when they're flirting with someone, or and they start a relationship. It would be dangerous to rely on this case to say their relationship hasn't started, wouldn't it? Our advice is always err on the side of caution. As soon as you start having a kind of a relationship, like the court.
I think it would be dangerous to rely on any decision under Section 2D about when a relationship begins as a precedent, because as Vivian said, it is so fact specific. So even something like moving in together is not going to be the end of the story.
They looked at emails in which she talked about calling a flat meeting and things like that were evidence of what was the stage, because it's that crucial point of at what point do property implications arise from a relationship, because Shelley and I don't have any claims to her assets, but you can see when a personal relationship develops, there starts to be, we've already got, anyway.
It's deeply contextual, and it does involve an examination of the facts, an intense examination of the facts. And that's one of the consequences of bringing de facto relationships under the umbrella of the Property Relationships Act. And mostly we're managing that pretty well.
Do you think
on a daily basis, I think people just err on the side of caution.
That's right.
Take the earliest date that you think your relationship could have started and start thinking about...
Because there are plenty of cases where they said the relationship has started quite early on too, and then people have been caught. What does Sutton and Bell add to the discussion about when a de facto relationship start? How should this change the advice we're giving to clients?
It's less about when a de facto relationship starts. It's more that it has implications about when a couple might be considered to be on the cusp of, and the words used in the Supreme Court were
Clear and present
intention. And that's kind of not a bright line test as such, but it sort of illuminates that point at which a disposition will be very vulnerable.
Yeah, and that leads us perfectly to Section 44 discussion, part of the discussion. So Sutton and Bell in the Supreme Court obviously mainly concerns the meaning and reach of Section 44, which, if you recall, says that the court may make orders where a disposition has been made by one party in order to defeat the claim or rights of another person. Now, once the High Court had decided the de facto relationship had started in December 2004, and not when they'd moved in together, and therefore after the agreement for sale and purchase had been signed to sell the house to the trust, the argument became about Section 44. So tell us, what does Section 44 mean, and what does the case tell us about when it applies?
Well, I'll start, and Sam, I'm sure you can
jump in.
So the thing about Section 44 is there was no need to give it a kind of a broad and generous interpretation, because the section itself is very broadly worded. It talks about a person, not a spouse or partner. It talks about property. It's not about it being classified as relationship property when it's disposed of. And so what we encouraged the court to do, and the court did do, and in fact it had done it at the Court of Appeal and High Court level, was to apply the sort of plain and ordinary meaning of the words to allow for a disposition that had occurred prior to the de facto relationship commencing. The neighbouring sections, 44C, D and F, E and F, require there to be a spouse or partner, and they do require the disposition to be one of relationship property. Section 44 itself didn't. As to the intent to defeat, all the Supreme Court did about that was just to affirm the already existing position, which was to apply a case in a commercial property context, which meant that you didn't need to prove fraudulence on the part of the disposer. It was sufficient if there was evidence of the knowledge of the consequences of the disposition.
And that's where the advice and the email come into it, right? And what did the court say about whether Mr. Sutton had, about whether he had transferred it in order to defeat her interests?
Well, the Supreme Court upheld the lower court's decision that there was clear evidence that Mr. Sutton had that knowledge when he made the transfer, and the email was one of those factors. Other factors were his recent experience with his own separation, the advice he had received. What else was there? He didn't have children at the time it was transferred. But certainly that email was evidence that he knew that would be the effect.
Yeah, and so it didn't need to be in secret, did it? Like in Regal Castings, that guy was transferring, was it diamonds? He's transferring something out to defeat a creditor in secret.
He was transferring his home. He was a manufacturing jeweller.
Okay.
There were diamonds in there.
Diamonds were involved, but it's not blood diamonds. But what was really interesting is that we argued, and the Supreme Court accepted, that in the context of a relationship, it wasn't a necessary ingredient to prove that the disposition occurred in secrecy, because we see, look, relationship dynamics are such that there may be discussion, pillow talk about, well, I'm transferring my home to the trust. The relationship dynamics are such that, you know, where there's one party who's in the stronger financial position, the other in the weaker position, that one's not going to be able to do anything about it, are they? Why must there be an ingredient of secrecy or an extra element of dishonesty? The Supreme Court found that was not necessary for the section to be engaged.
So did it matter that his expressed reason was the rest home fees, and his grandmother had lost out on money? She'd had to pay rest home fees because she hadn't put her property in a trust in time. Was it,
No, because one of the consequences of Regal Castings being applied in this context was that you no longer had to show that you had a dominant motive of defeating interests. It removed the the distinction between the motive and the intent. It was enough that you could simply show knowledge of those consequences. It didn't matter if you had another benign purpose like tax or home subsidies.
Is that a pragmatic call because it's so hard to prove that?
I think what it is it's an evolution from the Coles and Coles approach, which Sam mentioned, where the threshold was placed really at a very high level and required the wife in that case to prove that the husband had fraudulent intent. And I just think that when that was in the 1980s, that case, I think we've evolved from that to realise that relationship dynamics are such that sometimes one partner might want to cheat the other out of their entitlements, and so we're not making that gate so high that it's impossible to cross as a hurdle.
Next question. There isn't an automatic right to appeal to the Supreme Court. You need to get leave. In this case, there seemed to have been a lot of consensus as it worked its way through the courts about Section 44 applying. How come this one went to the Supreme Court?
Well, we obviously opposed
We
that.
did oppose it quite strenuously.
I mean, in order to get leave to appeal to the Supreme Court, you have to satisfy Section 74 of the Senior Courts Act, which you have to come under one of the various pathways. So you have to show that it's an issue of significant commercial or public importance, or that there will be a substantial miscarriage of justice. There's one more that I can't remember now.
It was really about the novelty, and certainly that issue, and the Supreme Court judges acknowledged this when we were in court, this issue hadn't actually come before the court before, as to whether you could have an intent to defeat, or you could dispose of something in order to defeat where there was not a de facto relationship in place at the time. So that was the novel question.
And an issue of public importance.
Right. So it just hadn't been decided at a high enough level, because the Court of Appeal is quite a high level. Often you'd stop there, eh?
Yes, so
Anyway.
it was wanting the last word from the Supreme Court.
Yeah, okay. Great. Were you ever in any doubt about the outcome?
I mean, I don't think you can ever be certain about the outcome.
No,
So-
definitely. There were some very strong arguments raised by the counsel for Mr. Bell and Mr. Sutton, and they did a really great job, a really excellent job. They pulled out all the stops. They dreamt up some really interesting arguments, and as is always the case, when you get the submissions from the other side, you take a deep breath and try and think, well, is that right? Or that might have some legs, So yes, certainly didn't think it was, a done deal. No.
What about when you walked out of court on the last day? How did you feel?
I mean, I think the hearing went really well, but it's the same. I mean, the other side did a great job, and you really don't know.
Yeah, I mean, Linda Kearns for Mr. Sutton and John Billington KC, or Linda Kearns KC as well, both did a fantastic job, and we felt it had gone pretty well for us. We didn't get a roasting with a blowtorch under the feet, which was helpful. But then I have been in court sometimes and felt things went reasonably swimmingly, and then only to find the decision doesn't go your way. So you don't want to be too overconfident.
How long did you have to wait? How long do you wait for the decision?
Oh, we waited for the hearing was in August 2022
Until 1 June was
Yes.
that?
Wow, that is a long time.
And it can happen the other way around as well, where you think, oh God, and then it's happening.
But it's very difficult for the clients to wait for that.
Yeah, that is a long time.
But it's important that the judges have time to really consider it and get it right. So it's understandable.
Yeah.
And it is the kind of last port of call for everybody.
Exactly, A lot of people are going to be relying on it, aren't they?
Yes.
Yeah.
So is preparing to appear in the Supreme Court very different to appearing at the lower levels? Do you have any tips for lawyers on how to run a case at the Supreme Court?
You just need to pour yourself into it, don't you? Time-wise, we just practiced and practiced, read all the decisions again, read them back to front, talked about it, pulled our hair out, and a really good time to start that hair pulling and rereading and so on is when you're filing your own submissions, because you tend to do that at that stage, and then in preparation for the hearing itself you do it again. But yeah, there's so much preparation involved. It's just
how long does that take to prepare?
Days and days.
Yeah.
And then there's some practical things like being ready to address 5 judges and sort of make sure you're not speaking to just one side of the bench. And then they have some, electronic case things which are quite handy, but also you need to get used to telling the clerk to be able to pull up the right document. But they're all,
Right.
But they're important because they can really throw you off if they go wrong. So,
Cool.
Okay, can I do one
Yes.
ad hoc question? When is it safe for a single person to put their house in a trust?
well, when in doubt, contract out is a good sort of...
Is it ever safe?
Yeah,
You
is
know,
it ever
yeah.
safe?
Well,
is it
this
ever worth it as a single person to put your house into
I
a
think
trust?
the way I described it was there was a legitimate pathway out of this regime. Through the front door was a contracting out agreement. What happened here was he climbed out the bathroom window. So, that wasn't the legitimate pathway out of the Act. If you don't want to be part of that regime, you certainly can. You've got autonomy. But the way to do it is to ensure both parties have independent legal advice, do it properly.
And it sounds like she would have done it at that point as well.
She
possibly.
probably would have, funnily enough. Yeah, that's right. Exactly.
In the first
But then
first blush of romance.
she might have been advised.
Yes,
If someone
exactly.
in her position had come to me, I would have said, well, you might be in your stilettos now and feeling financially independent. But, a few years down the track, if you've had a couple of children and they're around your ankles and you're not working and you're wearing slippers, I describe it as a stilettos to slippers sort of transition. You might not be able to contemplate that. It's like somebody packing for a cold climate when they're living in the tropics. It's really hard to imagine, but you will be in a position perhaps where you're feeling vulnerable, and do you really want to have nothing if your partner leaves you after 10 years and you've got small children and you've given your life to those children and your husband? Do you want to have nothing? What about a staged process so that over a period of time, as the relationship continues, you might have a share in that home? You might have nothing now, but then a gradually increasing share. And most good lawyers would have advised her to that effect.
And one of the things the Supreme Court said about that email, when it was said, she was supporting this decision, was, she may have been then, but she probably wouldn't have, a few years down the track after their children had been born.
Yeah, and I know that the judge read that as suggesting, and so when she said, I'll just stay 6 to 9 months, and those sort of things, the judge saw that as an impermanent and unsettled relationship, or not relationship, living arrangement. I kind of see that as a young woman who was really wanting the relationship to continue. She knew that the father-in-law or his father wouldn't want them to move in because of the property implications. She wanted that relationship to progress. I mean, I'm not inviting you guys to speculate. It wouldn't be appropriate. But for me, that's a woman who wants the relationship to continue and will sacrifice herself in her own interest, because you hope in your heart of hearts later on down the track, he's going to look after me. He'll, am I too soft?
No, I think there's many ways of viewing the facts in the case,
I think it might be time to go to the quick five.
Quick five
and
questions.
they need to be really quick.
Okay, all right. Okay. The Linda Cairns one, I would love to know your answer on that one, but about if you've ever seen Section 26 or Section 26A, the ability to settle property on the children or delay. Have you ever seen that happen?
Yes.
There are cases, yes.
Yeah. Which would be the case that you...
A case I was involved in where there was a disposition of family money to a trust. Yes, it was to a trust, and then the judge found that the trust should then be modified so the parties were both trustees and an independent trustee, and there was a disabled child involved. so it was set up for that child.
Yeah, it seems to be more common then. Okay, quick fire questions.
How could Mr. Sutton have achieved his goal of ring fencing the family home as separate without sacrificing years of his life and many thousands in legal fees? I think we've answered
Contracting out agreement.
Contracting out. Say it again. When
in doubt, contract out.
Love it.
Yep. Should there be no distinction between a family home owned by a trust and one owned by a party?
I don't know about that.
You've got a 10-second answer.
No, I don't. I think there should still be a distinction. This is about dispositions being clawed back where they're really not legitimate.
Where she should have had some advice on it.
Have you ever met a trust you liked? All of the ones drafted by Henderson Reeves, of course.
Have you ever used a raffle to promote your legal services?
No, I haven't considered that to be necessary thus
She doesn't
far.
need a raffle.
So how long have you, hang on, start that again. So how long have you worked with Viv Sam, and did you expect to be going to the Supreme Court so soon?
I have worked for Vivian since March 2020, so a couple of weeks before our first lockdown, which was supremely timed. And no, I did not expect to go to the Supreme Court, absolutely not. It was,
Awesome.
Okay, what was your most memorable moment in the Supreme Court hearing? You can both answer me that.
I think probably when the judges came in at the beginning and took their seats and sort of kicked off.
Are they gowned and wigged?
Not wigged.
They're not wigged,
Okay.
but they wear special gowns. For me, the most memorable moment was when Sam and I were able to address the court, because the real advantage being a respondent, which we were acting for, was you could see the way the court was reading the appellate submissions. So there was a sense of relief almost when we were able to address the court. This
No
is the
surprises.
way it is.
Yeah. Did Viv at any time gesture to you out of the blue and say, "And now my learned junior will take over the argument"?
No, unfortunately. I don't think she would be that
Too
cruel.
good manners.
But Sam did do. She ran part of the argument, so there wasn't an impromptu.
No.
That wasn't an impromptu.
I'm
So
guessing
that's
there's
just
not
my
much.
father who does that.
And probably not in the Supreme Court. So,
I nearly did it on Tuesday, didn't I?
have you ever cloned your hard drive?
I haven't really provided the context of this one. The context of this one is the emails. It was an exciting part of the case, actually, we missed out. The emails were like last minute evidence before the second family court hearing. And
The High Court hearing. It was the High Court hearing. It was before the High Court hearing.
Because they cross-examined. They cross-examined in the family court.
Yeah.
On those emails, so that's why in the High Court they said that they were allowed in as evidence to appeal the first decision because they'd been cross-examined on. I think
There were further new emails.
But there were new
there were
emails.
further new ones. Right. Okay. Yes. So they came out just before some of them before the family court second hearing, some of them before the High Court, and he had been able to unlock. He had found a cloned hard drive of his ex-partner's laptop or computer that she'd removed from the house. He found a cloned hard drive in a cupboard, and he wasn't able to unlock it, and then he finally was able to unlock it just before the hearing and came up with these emails that he said were the smoking gun of, she didn't move in because I loved her, she moved in because she was financially in difficulty. And
Who
That's
cloned
kind of-
the hard drive?
well, yeah, that's exactly. So that's the context to the who, have you ever cloned a hard drive? It seemed like an
And goes
unusual
right
thing
in-
to happen.
Right into
So,
your
no.
next question.
No, I haven't.
Should we?
Nor me.
So then the next question,
Which is you?
did anyone suggest that the story about the recovered cloned hard drive sounded fishy?
No, but there was some criticism of Ms. Bell for having not provided the hard drive and having sort of sat on emails. But that was quite a difficult conclusion to draw really on the facts. I would have thought it was sort of taking it a bit further than
Because
that
you don't
would be reasonable.
you
because
don't
not
hand over-
everybody has records of old emails.
and you don't necessarily think all old emails are going to be relevant. You submit the ones that you think are relevant,
From
right?
2004, 2005.
It was sort of difficult to draw, cast aspersions on her for having sat on the emails, I thought.
Okay, what is your top tip for helping someone who is so in love that they will sacrifice their own future survival?
You go.
Oh, just, a bit of hard-edged reality checking. Take your glasses off and
And your stilettos?
and your stilettos.
Walk around in slippers for a while. Go and see a lawyer, maybe.
Well, I'm
when
sorry.
you
I
are
thought
a
we
lawyer.
were.
Yes, yeah.
I thought we were talking about that. But it is really important to. It's hard to persuade somebody when they're in the throes of romance that the person, with whom they're so in love, might actually not behave, ethically or fairly towards them if the relationship meets its demise. So it's hard to do that, but you've really got to put to them possible scenarios. Most people don't like the thought of their partner, wife or husband, going off with the neighbour, and how they might feel if that occurred. Yeah,
and even if you've got the most lovely partner in the world, what two people think is fair, or what a person thinks is fair, isn't necessarily what's fair in the eyes of the law.
Objectively
fair.
fair,
So
yeah.
they might be thinking that they're being perfectly, a good ex-partner, and maybe not being fair in the eyes of the law. Next question. I like shiny things, but I'd marry you with paper rings. Is this A, a line from a hit song by Taylor Swift, B, an excerpt from one of the recovered emails, C, an example of the self-sacrificing tendency of young women that is exactly what went wrong in this case? It's kind of a trick question.
A and C.
Okay, next question. Did you wear your lucky purple jacket? But maybe have a lucky green jacket now.
No, I didn't. Because you have to wear your blacks and whites. I had my bar jacket and, white shirt underneath and the gown and so on. So we were black and white.
Mm-hmm.
Yeah.
And so now it's time for the best question ever. And this is mainly for you, Viv. What is it about you that means you can fight these long-running battles? This one wasn't so long-running for you, and still love your job. Where does the courage to fight and fight again come from? What advice would you give someone like Sam that will see her continue to love her job well into the future?
Gosh,
Maybe that's
and
the
it
trick
does
question.
it does require courage, and it does require toughness, and I guess the thing that really helps is actually doing something together, so being part of a team, and this was very much a team effort. If I'd been doing this entirely on my own, it would have been so much harder. It sounds really trite, but to be able to do this in the long haul, having sort of a bigger picture in mind, it's really important to take care of yourself. So I run, having time off, not constantly being available 24/7. Just burnout is a real problem, particularly in family law, because many of the people who come to see us are highly distressed. And so you need a break from that. And you also need thinking time to be able to think of arguments. So the appellate work requires real thinking at quite a deep sort of level. The day-to-day trial work and cross-examination is different. You're thinking really, really about facts and what you're testing and so on. So, but doing things as part of a team is just, I cannot say how helpful that is. I mean, I had that case that we talked about on the last podcast. Initially, I was doing that on my own. It was so hard because I had a fantastic team on the other side, Simon Jefferson and his team, and I got Louise Reid involved in that, and it suddenly turned. It was really helpful.
Awesome. Yeah. Well, thank you so much, Vivian Crawshaw, Casey, and Sam Wilson, barrister. It's been such an interesting and entertaining talk, and thank you for the good work that you're doing.
Thank you.
Thank you very much. Thanks for having us.
And this has been Divorce Cafe. If you'd like to check out the other episodes, we'll see you next time.